Hi friends, today we're going to be talking with Laura Nash Frisch from CVIC as well as Representative Zac Ista. They're going to be sharing more about House Bill 1489, which combined 3 protection orders into one. Today we're talking about House Bill 1489, which was an attempt by the North Dakota Supreme Court to combine several different types of protection orders. Can you maybe just explain a little bit about what this bill is intended to do for survivors?
Yeah, this bill I think is going to give a little more clarity to those who need protection from the courts based on conduct they might be experiencing or a living situation that's no longer safe for them. As you know, here in North Dakota, we have 3 types of protection orders or restraining orders. One's called disorderly conduct restraining order. There's the domestic violence protection order and the sexual assault restraining order. And those are available to different types of folks depending on the type of conduct they're experiencing or the type of relationship they have with the person who alleged to be committing that conduct. And under current law, before we came into the session, those are kind of spread out throughout North Dakota's century code. And the Supreme Court took the lead and said, you know what, this is confusing not just to those who might need the protection of our courts, it's confusing to our judges, lawyers who work in these spaces, advocates like CVIC who have a role to play here. So really a lot of credit goes to the court for saying, let's get these all into one nice code section so that they're all treated the same, that people who work in this space can give clear, consistent advice and help push people towards the right protection order for them, but not get caught up in the different ways we treat those under the law. Let's leave that to the courts and to the attorneys to worry about.
Well, and maybe Laura, you are our Vice President of Victim Witness and Visitation at the agency of CVIC. Can you maybe explain how our advocates interface on these protection orders?
Yeah, so under North Dakota law, Rule 34 allows advocates to provide some assistance to pro se litigants, which means they are representing themselves. So the advocates aren't providing representation, but they're helping to be that guide through the process from the time that they first fill out that protection order application up through the hearing and when that order is potentially extended.
How about the bill? It went through a number of iterations. Of course, we've landed in a great spot. But can you maybe talk a little bit about some of the original language and why we opted to advocate for some change before it was finalized?
So it's incredibly complex. As Representative Ista mentioned, these are 3 separate sections within the Century Code, and to put them under one bill and have it be a little bit consistent when there's different relief provided to applicants for the different types of orders. It was incredibly complex, and we really wanted to make sure we didn't lose some of the things that we advocated for in previous sessions, like stalking becoming part of the definition of domestic violence conduct. So that remained in the bill. Some things like a minor of sufficient age and competency being able to apply for an order, that was something we were seeing that was inconsistent across the state. Some jurisdictions were allowing it, some were not, some were requiring a parent to be involved. So that was something that was changed. And then we also were able to get online access to the victim's name or the applicant's name to be redacted so that we weren't in violation of the Violence Against Women Act. There's specific privacy and confidentiality that are afforded those victims, and so we were able to get the law in line with that as well.
Well, it sounds like we landed in a great place, and I know there'll be some training for advocates as we do this blanket approach. Is there anything else you wanted to share with our viewers?
Well, I think another important protection in the law that passed is not just protecting the names in those publicly available filings, but protecting the proceedings themselves, making them closed court proceedings, that only the person needing protection and the one who's alleged to have committed the misconduct, only those and the appropriate parties representing them are allowed, including advocates from places like CVIC. We don't want to put any barriers in place for people who might need to avail themselves of one of these protection orders. So making sure our statutes are clear. It also makes sure there's no filing fees or service fees for anybody needing protection, and then making sure they don't have to worry about their name being not confidential or the hearing being open to the public. I think there's all 3 important things that are going to help those in need of protection come forward. And another tool on the back end of these is if somebody violates a protection order that's granted, we have now standardized how the law treats that as a criminal offense. That if it's the first time, it's a misdemeanor. If it's the second or subsequent times, it's going to be a felony. So really put some added weight behind the criminal enforcement of these civil restraining orders.
That's such a great point, Representative Ista. And I so appreciate you both being here today. And I'm sure we'll be back again next session to see what else you can help us with, Representative Ista.
Looking forward to it.
Thanks.